All right, good morning. Welcome to the 294th District Court. My name's Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Joshua Cohn. Where are you at, Mr. Cohn? Mr. Cohn, come on up here and have a seat in this jury box. Michael Gatlin. Go. No. Don't get up, Mr. Gatlin. I'm just asking you to say if you're here or not. Are you here, Mr. Gatlin? All right, I see you. Jatavius Malloy. Joseph Melvin. Joseph Edward Melvin. I think he may be in Smith County. We'll recall that case. Talk about that one. Antonio Robinson. Isaiah Rosser. Isaiah Jabrier Rosser. Robert Solis. All right, make sure you say something. Might not be looking up. Wayne Turnage. Wayne McKinley Turnage. All right, the surety has filed a 1719. The court was taking that under advisement to see if Mr. Turnage appeared. He has not. The court's going to grant that 1719 and issue a capias. Brandon Verge or Verge? Is it Verge? Is it Verge? Okay, sorry about that. James Wyatt.
Great.
Joey Greer. All right. Mr. Greer is here for the record. He's meeting with a pretrial release officer. Sean Davis. James Grossel. Thanks, sir. Larry Jackson. Thank you. Dante Major. Guy McSpadden. Joshua Morgan. Jarek Munns. Timothy Peyton Quarterman. David Pinkerton. David Bradley Pinkerton. Jenna Prox. Gina Prox.
Ms. Prox had emailed me before court this morning. She said that she got stuck in a couple school zones on her way from Oklahoma, but she is on her way, and she believes she will be a couple.
Okay, thank you, Mr. Manning. Trevor Rogers. Adam Scott. All right, is there anyone in the courtroom and I've not called your name and you expect to be on the docket? All right, I see no one. Mr. Manning, you ready?
Sure.
Who are you ready on?
Larry Jackson.
Mr. Jackson, if you'll come forward, please. Oh, that's okay. That's all right. Let's go to the next one. Mr. Major. This is cause number CR 24-214, State versus Dante Marquez Major. Mr. Major is here on the state's motion to adjudicate.
Yes, Judge. The state has made an offer, and I have not had a chance to talk to my client about that. We are currently set for August 27th. So if we just keep that setting for August 27th, I'll discuss the offer with my client, and we'll obviously that we should have a resolution or have it.
All right, very well. Court will maintain Mr. Major on the 27th docket at 9 a.m.
Would you like to confirm what we said?
I think we've already said it. Yeah. So, Mr. Major, just know you're not getting another reset today, but you've been previously ordered to be here on the 27th of August at 9 a.m.
Next, Mr. Joshua Morgan.
Joshua David Morgan, CR 22-279-309. All right, Mr. Morgan is set for compliance status.
Yes, Judge. Mr. Morgan has been on compliance for quite some time now. He did make a payment towards his balance this morning, $100. Judge, he has experienced, due to him working to get caught up on service hours, he experienced some financial difficulties. but he anticipates being able to wrap those up shortly. Judge, we'd ask, he is the court lister, so like to stay on the compliance docket, we'd ask for a little bit longer setting. Otherwise, I think the state, at some point in the past, the state was amenable to withdrawing and continuing him to support us into his probation. I don't know if that those criteria has been yet for that.
Mr. Hernandez, any opinion?
No, no.
Okay. Any objection from probation? How long are you looking at, Mr. Manning?
Judge, if we can set it,
Like October? Actually,
Yes.
no, you're not available in October. Well, actually you are, but
it's-
you're not available in September.
we can set it October 5th.
All right, court sets him October 15th for status.
And Judge, in that interim time period, I'll be with the state and see if the necessary benchmarks of events to release them from the compliance docket.
Who's next?
Next, we have Mr. Munns.
Jarek Chase Munns, CR 25-100, CR 25-237. And Mr. Munns, I believe, is here on status awaiting announcement regarding the federal sentencing.
That's correct. I spoke to Mr. Munns last week and checked on his status. They have still not completed the sentencing process. So we've asked for a reset on his case.
What's the update on when they're going to complete the sentencing process?
Judge, I believe that everything has been done on Mr. Munns' part in terms of submitting to the evaluations and analysis for his credit time in the federal system. I think it's simply in the hands of the court at this point. His next reset is
Recently, petition contact. You know, I'm not gonna have the opportunity to appeal anything and help get my sentence back.
All right, court's going to set Mr. Munns October 15th. At 9 a.m. Who's next?
just next for Mr. Pete Portman.
Timothy Allen Peyton Quarterman, CR 2686. And Mr. Peyton Quarterman is set for arraignment on second-degree felony offense of possession of controlled substance.
For Pete Portman's name is spelled correctly, he understands the charge against as well as the punishment. His plea is not guilty. We have received a plea offer, but we are working on an potential negotiation, so we request to be set for pretrial for us with them to negotiate.
All right, court sets Mr. Peyton Quarterman for October 15th for pretrial at 9 a.m.
Good, Mr. Pinkerton, I will reach out, see, when you last time I tried to communicate with my office, see if I can get it. Mr. Rogers.
Court call CR 25-283, State versus Trevor Alexander Rogers, pretrial.
Good, we have no potential pretrial issues this time. Additionally, that we have received an offer of negotiation. Request we set on document.
All right, Mr. Manning, I'm going to set final docket call October 15th. I know it's the first, but it'll also be the final since we're skipping September.
Yes, sir.
So,
And Judge, we do have some stuff, I was negotiating with Ms. Curry, I have some stuff for her, that should, give us kind of their recommendation of which path. to take.
yes, sir.
Scott?
Court call CR 24-291, State versus Adam James Scott on the state's motion to adjudicate. I believe he's already set on the 27th. Do we have a resolution today?
We don't have a resolution today, we have received an offer, we've made a counter offer, and the state has requested continue, the state and defense requested continue negotiations on Mr. Scott.
All right, so we'll continue with the hearing on the 27th. So if there's no resolution and agreement on that day, then we'll have a contested hearing.
Okay.
All right, so you're free to go.
Judge, additionally, I don't know if the board has provided paperwork on this. My understanding was with the agreements that would be withdrawn him to go to the VA hospital, for dual diagnosis treatment.
I don't have any paperwork yet, Mr. Maine.
Judge, I'll track that down, see if we can get that.
Okay.
I was provided for two arrangements, two different individuals. Mr. Wyatt and Mr. South.
Yes. You ready on this?
Yes, sir.
Robert Alex Salas, CR 2687. All right, Mr. Salas has been indicted for the third-degree felony offense of possession of a controlled substance. He has requested court-appointed attorney. The court has found him indigent for purposes of the Sixth Amendment and has appointed the Honorable Jonathan Manning. Mr. Manning, are you ready for indictment? Or I'm sorry, you ready for arraignment? And have you been provided a copy of the indictment?
Judge, I have been provided a copy of that information.
Yes, sir, go ahead.
Mr. South, is your name spelled correctly? Yeah. Okay, and you understand you've been charged with a third-degree felony, arraignment punishment for a third-degree felony is 2 years up to 10 years, and to it's about one. Understand that? You understand that charge is for possession of controlled substance, penalty group 2, 1 to 4 grams. At this time, Judge, my client said this spelled correctly, he understand the charge relating to punishment, or plead not guilty and practically set on a pre-trial docket.
The court enters the defendant's plea of not guilty into the record and sets the defendant for pretrial hearing on October 15th. At 9 a.m. Mr. Wyatt. Cause number CR 26-82, State versus James A. Wyatt. Mr. Wyatt has been indicted for the third-degree felony offense of possession of possession of marijuana greater than 5 pounds, less than 50 pounds. The court has found him to be indigent upon application for purposes of the Sixth Amendment and has appointed the Honorable Jonathan Manning. Mr. Manning, have you been provided a copy of the indictment? Are you ready for arraignment?
Yes, Judge, I have it for the copies. Mr. White is your name, so, sorry, Mr. White, spelled correctly. And you understand that judges informed you that you're being in charge of possession of marijuana, a third degree felony, and that range of punishment is 2 years, 10 years, up to 10 years, that's what you understand that? Okay. Judge, at this time, I say this spelled correctly, we request, consent to the docket and please not rules.
All right, the court enters the defendant's plea of not guilty into the record. Court finds that he's waived the formal requirements of arraignment and enters his plea of not guilty and sets this matter for pretrial hearing October 15th at 9 a.m. Ms. Burns, do you know if Mr. West has met with these people that are new on arraignment? Mr. Wyatt, have you met with the court's pretrial release officer yet, Mr. West? Have you met with the court's pretrial release officer, Mr. West? Okay, then once you get your paperwork, have a seat in the hallway. Once he talks with you and goes over the paperwork, then you're free to go. Go. Took off on me. I don't know if you want to text Karen and find out about Mr. Salas. He's probably the one that I didn't ask about that needs to be on. He's on his list. Well, I know he might be on the list, but if these people are leaving, they don't know to see him. Mr. Hawkins, are you and Mr. Greer ready? Okay, is he being UA today? Okay. All right, we'll recall him when he's ready. Michael Gatlin. Hmm? Right there, sir, it's fine. This is cause number CR 26-83, State of Texas versus Michael Adolph Gatlin. Mr. Gatlin, you have been charged by indictment. Can you hear me okay? Okay. You've been charged by indictment with a third-degree felony offense of possession of a controlled substance that does carry a range of punishment if you were to be convicted and sentenced to not less than 2 years in prison or more than 10 years in prison, and you could also be fined up to $10,000. Do you intend to hire an attorney in this matter? All right. Do you believe that you are indigent? Do you believe that you are indigent, that you're too poor to hire an attorney? Okay. What I'm going to do, so are you requesting a court-appointed attorney? Okay. So in order, before I can do that, I have to review your financial information that you have to provide. So have a seat in the hallway. This is Ms. Taberham. She's going to bring you some paperwork. You'll fill that out and she'll get it back from you. You'll come back in the courtroom. Once I review it, I'll make a determination as to whether you are entitled to a court-appointed attorney or not. All right. Thank you, sir. Jatavius Malloy. This is cause numbers CR 26-57, CR 26-58. Mr. Malloy, you have been indicted with 2 charges. One is a third-degree felony, possession of marijuana greater than 5 pounds, less than 50 pounds. That carries a range of punishment of not less than 2 years in prison or more than 10 years in prison, and also a possible fine up to $10,000. You've also been charged with unlawful carrying of a weapon, which is a Class A misdemeanor. You could be sentenced up to 365 days in the county jail and also fined up to $4,000 for that offense if you are to be convicted and sentenced. Do you intend to hire an attorney to represent you on these charges?
Yes, sir.
All right, so what I'm going to do, Mr. Malloy, is I'm going to reset you for about 30 days to give you time to go out and hire an attorney, okay? Today is August 13th. I'm going to have you come back on September 17th. All right. So that's going to be at 9 a.m. And we're going to give you a form here. You're going to sign that form. That's just indicating when you're going to come back. All right. And then let me see that, Miss Tabraham. I want to see if I'm going to write on here what your charges are when you go to talk with your attorney. Make sure that you bring this with you so they understand what you're charged with, and that will give them additional information to assist you. Okay. Check off on the bottom that they're to hire it. I want you to meet. Have you met with Mr. West yet, the pretrial release officer? He's gone over your conditions, correct? All right, then you're free to go. Court call CR 17-63, State of Texas versus Joseph Edward Melvin. The court has confirmed that Mr. Melvin is still in custody in Smith County on the charge of assault of a hospital personnel or on hospital property. Looks like he was arrested June 4th of 2026 and remains in their custody. Court will reset this for status of custody on September 17th. And Mr. Hernandez, if you could inquire with Smith County, find out what their prosecution looks like over there as far as timing, dates, that would help us to know when to reset him or when to request a bench warrant. Antonio Robinson. Okay, good. All right, this is cause numbers CR 2663 and CR 2664, State versus Antonio Kimtrell Robinson. Mr. Robinson, you have also been charged with two crimes. One, a third-degree felony, possession of marijuana, 5 pounds to 50 pounds, and also a third-degree felony offense of unlawful possession of a firearm. Both of those crimes independently carry possible sentences of not less than 2 years in prison or more than 10 years in prison, and also possible fines not to exceed $10,000. Do you also intend to hire an attorney to represent you on these two felony matters? All right, so Mr. Robinson, I'm going to set you also for September 17th for you to have time to hire an attorney. I'm going to have you sign this notice of appearance. And you need to make sure that when you hire an attorney that you're hiring a criminal defense attorney. Okay. And then you need to make sure that that attorney is willing to practice here in Van Zandt County. Sometimes people get reset and they go spend time talking to attorneys only to find out that the attorney says, yeah, sure, I'll take your case. And then they find out that it's a county or two counties away, and then they tell you that they're not going to do it. So make sure that they know that the charge is down here in Van Zandt County, and that they're willing to come and that it's a criminal attorney that you're talking to. And you've seen Mr. West, the pretrial release officer? Okay, then you're free to go. Do you have any questions? Okay. All right, Patty, I'll sign that 1719 on Mr. Turnage. Brandon Verge. These photographs. All right, this is cause numbers CR 26-66, CR 26-67, State of Texas versus Brandon Demond Verge. Mr. Verge, you were also charged with 2 felony crimes, both or 1 third-degree felony, a possession of marijuana, 5 pounds to 50 pounds, and also a Class A misdemeanor unlawful carrying of a weapon. The felony charge has a possible sentence of not less than 2 years in prison or more than 10 years in prison. And the misdemeanor case, which is the unlawful carrying of a weapon, you could be sentenced up to 365 days in the county jail and also receive up to a $4,000 fine. Do you intend to hire an attorney to represent you on these 2 matters?
Yes.
All right. Court sets Mr. Verge then for status on attorney and arraignment for September 17th at 9 a.m. The same advice that I gave the previous young man, make sure that you're talking with criminal defense attorneys who are willing to practice here in Van Zandt County, okay? Have you met with the court's pretrial release officer, Mr. West?
Yes, sir.
Okay, good. Once you sign this notice, Mr. Verge, then you're free to go and we'll see you back on September 17th. All right, court calls, cause number CR 26-80, State versus Joshua Scott Cohn. You can just stay there, Mr. Cohn. Mr. Cohn, you are charged with a third-degree felony offense of possession of a controlled substance, a penalty group 1. And that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison. And you could also receive up to a $10,000 fine. Do you intend to hire an attorney to represent you on this matter? Okay. So what I'm going to do, Mr. Cohn, I'm going to reset you for arraignment and status on hiring an attorney for September 17th. That'll be at 9 a.m. And today the court, having requested a urinalysis test, finds that you have admitted to violating the conditions of pretrial release by consuming controlled substances. I'm going to find your bond insufficient at this time it's okay. It's okay. Court's going to find your bond insufficient at this time, and the court's ordering you to be taken into custody. So when you get into custody, Mr. Cohn, if you hire an attorney, that's great. They can contact the court and we can make arrangements for what's next. If you find that you cannot hire an attorney, then you need to request a court-appointed attorney by filling out the paperwork over at the jail. The jail will notify my coordinator and we'll review that. If you can't afford one, then the court will appoint you one. Okay? Yes, the court has set your bail at 50,000. All right, Mr. Hawkins, your client's still outside? Okay, okay. Court is going to stand in recess and give Mr. Hawkins, Mr. Manning time to work on their cases. Court will stand in recess for 20 minutes unless y'all notify me earlier that you're ready to go. Okay? All right, Mr. Greer is here on docket call today on the possession of controlled substance. Any announcement from the defense?
Government asked for, phone. Pick up these 6 new cases. As of, I think, this past week.
Any objections from the state?
No, Your Honor.
Okay. All right, court will grant, and this is going to be the final docket call, Mr. Hawkins.
Sure.
Court will set a final docket call September 17th. It's going to be at 1:30 unless Mr. Greer makes bail. Court finds that Mr. Greer has violated the conditions of his pretrial release while being rearrested for new offenses and also testing positive for methamphetamine. Court hereby revokes his bail, finds it to be insufficient, sets new bail at $150,000. Orders that Mr. Greer be taken into custody at this time. If he makes bail, then his hearing on the 17th will be at 9 a.m. If he doesn't, then his hearing will be at 1:30. Yes, thank you, Mr. Hawkins. Mr. Manning, you ready? Who would you like to call first?
Judge, we can start with Ms. Fox, because she did contact.
All right, Gina Lynn Prox, CR 24-220, CR 24-221. All right, Ms. Prox, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. Your name is Gina Lynn Prox, is that correct? And Ms. Prox, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? What have you been diagnosed with? Are you currently on treatment or medication for depression? Do you feel like your depression is in any way preventing you from understanding what's going on in court? Okay. And you are represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney and the work that he's done for you? Do you have any questions about anything that you have read and signed today? Mr. Manning, do you believe your client to be competent to enter into a plea agreement? And if so, that she's doing it intentionally, knowingly, and voluntarily after having been explained to her her legal rights and the advantages and disadvantages of a deferred adjudication plea?
I do.
All right, Ms. Prox, I see that on the charge of manufacture or delivery of a controlled substance in penalty group 1 greater than 1 gram or greater than 4 grams less than 200 grams, which carries a range of punishment of not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice. There is a plea agreement in which the state is recommending that the court consider the evidence, defer a finding of guilt, and place you on community supervision for a period of 6 years, a fine of $1,500, restitution of $180, court cost of $290, reimbursement fees of $535. And as part of the agreement, the state is dismissing 2 unfiled charges, possession of controlled substance and possession of marijuana less than 2 ounces. Ms. Prox, is that your understanding of the plea agreement?
And
All right.
then we could also dismiss CR 4221 and video estimation.
Okay, and let's see. Yes, there is an independent motion to dismiss and cause number CR 24221. All right, Ms. Prox, is that your understanding of the plea agreement, what you're asking the court to approve? All right, Ms. Prox, how do you plead to manufacture or delivery of a controlled substance in penalty group 1 greater than 4 grams, less than 200 grams? Are you pleading guilty to that crime because you are in fact guilty of committing that crime? Has anyone threatened you, forced you, or pressured you to plead guilty? All right, the court will accept the defendant's plea of guilt. Court also admits into evidence the stipulated evidence, and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, sir.
From the defense?
Rest of the.
All right, court will review the evidence. All right, and remind me, Ms. Prox, she was co-defendant with Mr. Williams, is that correct? All right. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict the defendant of the offense. The court will follow the plea agreement in this case. Court defers a finding of guilt, places the defendant on 6 years community supervision, orders her to pay a $1,500 fine, restitution of $180, reimbursement fees of $535, and court cost of $290. Furthermore, the court does dismiss under section 1245 unfiled DA numbers DA 2023-232, possession of controlled substance, and DA 2023-235, possession of marijuana less than 2 ounces. Also, the court does grant the state's motion to dismiss and cause number CR 24-221. Ms. Prox, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of this sentence. Well, and let me ask before I proceed, there is an enhancement paragraph in the indictment, is that true?
Yes.
Okay.
That's my request.
All right, let me ask Ms. Prox, you've reviewed the indictment and in that indictment, the court or the state has alleged to the court that you have previously been convicted of a criminal offense that would enhance the sentence and punishment range in this offense. Have you reviewed that paragraph? The allegation that is in that paragraph, is that allegation true or not true? True. All right. Court, and has anyone threatened you, forced you, or pressured you to plead true to the enhancement paragraph? Okay. All right. Then the court finds that Ms. Prox having pled true, the court finds that that is given knowingly, intentionally, and voluntarily, and the court hereby finds the enhancement paragraph to be true. All right, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted. After that, you'll meet with the probation officers. Mr. McSpadden,
Amber.
you may. All right, this is in cause number CR 22-36, State of Texas versus Guy Ezekiel McSpadden on the state's motion to adjudicate. Mr. McSpadden, if you'll raise your hand, I'm going to place you under oath. Do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. All right, Mr. McSpadden, you're here today on the state's motion to adjudicate. I see that you've reached an agreement with the state, and the state has filed a motion to withdraw its motion to adjudicate based on your agreement that your community supervision conditions will be modified for your placement into a Veterans Affairs facility, and that you would be ordered to pay $500 in additional new attorney fees based on the states having to file its motion to adjudicate and for you being appointed a court-appointed attorney. Is that you're asking the court today to grant the amendment and modification of your community supervision? Is that correct? And so basically it says here that as an alternative to going to prison, that you will submit yourself to the substance abuse rehabilitation treatment program through the Veterans Affairs in North Texas Healthcare System in Dallas. Is that correct? All right. And Mr. McSpadden, has anyone threatened you, forced you, or pressured you to make this agreement today? Are you pleased with Mr. Manning as your attorney? Mr. Manning, do you believe Mr. McSpadden to be competent to enter into this agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily?
I do, Judge.
All right, then, based on the evidence for the court will grant the state's motion to adjudicate. The court hereby amends and approves the agreement to modify conditions of community supervision to include an additional $500 in attorney fees and ordering him to attend the substance abuse rehabilitation program through the VA hospital in Dallas, Texas. And the court continues Mr. McSpadden on community supervision. All right, Mr. McSpadden, if you'll come over here and meet with the probation officers, get your paperwork, and then you'll be free to go.
Thank you, Your Honor.
You're welcome. Who's next, Mr. Manning?
You,
Mr. Gatlin, if you'll come forward. All right, this is cause number CR 26-83, State of Texas versus Michael Adolph Gatlin. Mr. Gatlin is charged by indictment and set for arraignment today on a third-degree felony possession of a controlled substance that does carry a range of punishment of not less than 2 years or more than.
Mr. Gatlin's here, so he's.
Okay, can you hear me, Mr. Gatlin? All right, Mr. Gatlin, you've been charged by indictment with a third-degree felony offense of possession of a controlled substance that does carry a range of punishment of not less than 2 years or more than 10 years in prison, and you could be fined up to $10,000. The court has reviewed your request for a court-appointed attorney. The court finds you to be indigent. The court has appointed the Honorable Jonathan Manning to represent you. Mr. Manning, are you ready for arraignment?
Yes, Judge. We have the indictment. I say it's spelled correctly. We understand the charge as well as the range of punishment. And he's not guilty. We have to be set a pre-trial docket.
All right, the court enters Mr. Gatlin's plea of not guilty into the record, and the court sets Mr. Gatlin for pretrial hearing on October 15th at 9 a.m.
Thank you, Judge. That's just acknowledging the freedom of return. And we just sign your name right there. Mr. Gatlin, be free to go.
Yes, free to go. Has Mr. Gatlin met with Mr. West? Have you met with Mr.
Yes.
Gatlin? Okay, free to go. You're welcome. Who's next, Mr. Manning?
Judge, an update from Mr. Pinkerton. I reached out and determined that Mr. Pinkerton was, recently arrested in Smith County. Warrant. I'm not sure the status as to where he was incarcerated, but, I believe he was picked up on county and, Smith County. Warrant.
Smith County warrant? Okay. Do you know if that was alleged to have occurred during his pretrial release?
I'm sorry, Judge.
Do you know if the arrest was for an offense that occurred during his pretrial release?
I don't know, and furthermore, was forfeiture of the surety, so I just became aware of this issue, this morning.
Okay. All right, the court will reset Mr. Pinkerton for pretrial October 15th. And the court finds his bail to be insufficient, and the court will issue new bail.
Yes, sir.
Who's next?
Jackson.
Mr. Jackson? This is cause number CR 26-37, State of Texas versus Larry Leroy Jackson Jr. Mr. Jackson is set for pretrial today.
Yes, sir. We have no contested pretrial issues at this time. We requested the case be set on top.
All right, court will set Mr. Jackson for final docket call October 15th at 9 a.m. And the court today finds Mr. Jackson's bail to be insufficient based on his violations of his conditions of pretrial release for controlled substances. Mr. Jackson is ordered to be taken into custody, and the court has set new bail at $50,000.
Yes, sir.
October 15th. You ready on Mr. Grossel?
Yes.
Mr. Grossel? This is cause number CR 25-202, State of Texas versus James Chandler Grossel. All right, Mr. Grossel, if you will raise your hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do, God.
All right, thank you. You can lower your hand. Your name is James Chandler Grossel, is that correct? And sir, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
Yes.
What have you been diagnosed with? Okay. Okay. Are you on medication or under treatment for those at this time?
Yes.
And do you feel like you have a rational understanding of what's going on in court today?
Yes.
Do you feel like your mental health issues are in any way preventing you from having clarity of thought to understand what's going on?
No.
Okay. In this case, you're represented by your attorney, Mr. Jonathan Manning. He's been court appointed to you. And are you pleased with him and the work that he's done for you?
Yes.
Do you have any questions about any of the paperwork that you've read and signed that's part of your plea agreement?
No, sir.
Mr. Manning, do you believe Mr. Grossel to be competent today to enter into the plea agreement? If so, that he's doing it intentionally, knowingly, and voluntarily?
I do, Judge, and on issue of competency, I will release the report, but I've had many meetings with Mr. Russell over the phone or email, as well as in person in the office. And I can also let the court know that Mr. Russell has been in continuous treatment or rehab for both the substance abuse and mental health issues since the early stages of this case. Additionally, Judge, as we get into the plea agreement, Mr. Russell is currently in an inpatient facility in Fort Worth through the VA hospital where he's receiving dual diagnosis treatment. And I've spoken with the probation department to match up with what he's be ordered to do under probation, which is a ISP, and what he's currently doing. He actually exceeds those requirements with what he's doing in the program forward.
Good. Thank you, Mr. Manning. All right, Mr. Grossel, you are charged with that first-degree felony offense of manufacture or delivery of a controlled substance that does carry a range of punishment if you were to be convicted and sentenced to not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice. You could also be fined up to $10,000. I see that the plea agreement in your case, upon you pleading guilty, the state's recommending to the court that you be convicted of the offense, that your prison sentence be assessed today at 10 years, that prison sentence be suspended, that you be placed on 5 years of community supervision or probation, that you be ordered to pay $750 in fine, $180 in restitution, $290 in court costs, and $535 in reimbursement fees, largely for the appointment of your attorney. In addition, as Mr. Manning stated, you would have to be on intensive supervision as a condition of your community supervision that coincides with your VA treatment. Is that your understanding of the plea agreement? Okay. And so at this time, Mr. Grossel, how do you plead to that offense?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
And has anyone threatened you, forced you, or pressured you to plead guilty?
Oh,
All right, the court will accept the defendant's plea of guilt, and the court also admits the stipulated evidence and takes judicial notice of the defendant's judicial confession. Anything further from the state, from the defense?
just briefly, Mr. Brooksall is prepared to make a significant towards his balance on this today. And he does that in an effort to first show his involvement in this program, but also take on the burden as he continues his treatment in the patient rehab and forward.
Good deal. All right, I'm glad to hear that. All right, then the court is going to consider the evidence at this time. All right, the court, having reviewed the evidence, finds that there is enough evidence to convict the defendant. The court will follow the plea agreement today. The court hereby convicts the defendant of the first-degree felony offense of manufacture or delivery of a controlled substance greater than 4 grams to less than 200 grams. The court assesses his sentence at 10 years confinement in the Texas Department of Criminal Justice. The court today suspends that sentence and places the defendant on 6 years of community supervision. I'm sorry, is that 6 or 5? I'm sorry, I apologize. And if I said 5, if I said 6 earlier, I apologize for that. Let me correct the record. The court suspends the sentence pursuant to the plea agreement and places the defendant on community supervision for a period of 5 years, orders him to pay a $750 fine, $180 in restitution, $290 in court costs, and $535 in reimbursement fees. And the court orders him to attend supervision as intensive supervision as a condition of his community supervision. And the court also takes into consideration Is that part of the plea agreement, the 1245s, or is that just a rejection by the DA's office? Okay, all right. So since it's not part of the plea agreement, I'll let that be off the record. All right, and so Mr. Grossel, the court has imposed the sentence, and you're going to be handed over to the probation department so they can carry out the terms and the conditions of your sentence. Do you have any questions?
No, Your Honor.
All right, come forward. I'm gonna have you be fingerprinted by Sergeant Martinez, and then the probation officers will give you more information about what's next. Who's next, Mr. Manning?
Judge, you're still, reading this paper down, I'm able to get that done. I'm really about the court. So it's something to about, his paper.
All right, let's go ahead and announce something. Mr. Davis, come on up. This is cause number CR 23-95, CR 23-207, CR 23-208, CR 23-209, State of Texas versus Sean Ray Davis. And it's been set today for entry of a plea agreement. I know that Mr. Davis is set number one for trial on August 31st. And the court had given Mr. Davis an opportunity to try to resolve his cases by plea. And I believe that he rejected all pleas at the docket call announcement. What is the proposed plea agreement today for Mr. Davis?
Judge, just to correct the record, Mr. Davis, we cannot show that Mr. Davis was ever provided any of the offers at his any previous setting. In fact, we just recently received this offer for the first time, and that offer is for 10 years deferred probation on a single count of possession of child pornography with dismissals in the remainder of the cases. And Judge, I believe there may have also been a fine as well. I just don't have that off the top of my head.
So you said it's dismissal of the continuous sexual abuse of a child, and then a plea to one of the cases of possession of child pornography?
That's correct.
And you said the recommendation is for a finding of guilt to be deferred and him to be placed on community supervision?
That is correct.
And for what period?
10 years.
Okay. All right, the court would not accept that plea agreement, Mr. Manning.
Judge, I would ask if there was a particular. And that is a legal plea, I would ask, if there's a particular reason why a plea agreement being reached after being offered for the first time would be not accepted, given that the victim or alleged victim in CR 2395 is in full support of this case, as well as the office and contact with all the parties who are in support of this resolution.
I gave the state and the defendant an opportunity to make this plea agreement back before we passed docket call. And my notes reflect that Mr. Davis rejected all offers at that time, meaning it didn't matter what the state had offered. I made that specific notation on my docket, which I always do. I always ask what the plea agreement is so that I don't get into a situation like an allegation that no offer's been made or a different offer has been made. And so the court is guaranteeing to Mr. Davis the jury trial that he requested. And I understand that there's a plea agreement and a recommendation by the state, but the court is not approving that or accepting it.
And Your Honor, if I may supplement the record as well, as late as yesterday, the day before, we were notified by the alleged victim that there's some HIPAA concerns and some things that are going on with her life. And we are expecting to receive, medical documentation to also, be, part of the record. So it may be that obviously if her doctor is advising, the state that placing her before the court and allowing her to testify would be detrimental to her mental health. That's just something that we haven't taken into account in the last few days. For that reason, that I think that it pressured us to really have those conversations with them regarding any plea negotiations, which of course, as Mr. Manning stated, she is all in favor.
I understand,
And
but
that was not known as of the last docket date. That was not known as of last week for that.
sure, I understand. But what Mr. Manning's indicated is that y'all's agreement is you are gonna dismiss that case anyway.
Yes, and
That's-
that's exactly what she's asking.
But then he also has 3 possession of child pornography cases that I'm assuming are not tied to that victim.
Judge, actually, if I may, part of the fact scenario is that a sitting individual is a witness in all of the cases. And so that same concern would apply to each and every one of those, that she is a material witness. That if the state didn't call, the defense would be calling, as a part of the case.
I understand, and I'm not gonna accept a deferred probation plea on possession of child pornography.
Judge,
And if you want to know why, because the court has the discretion to accept or reject a plea, and the court is rejecting the plea.
without even any offer of proof that would provide information as to why we've reached this particular.
Correct, and we're set for trial on August 31st, and I gave the defendant and the state a plea deadline, and that's been passed. And I know circumstances have changed, but be that as it may, the court still has the right to accept or reject a plea.
And Judge, I'm not arguing that, I'm just trying to figure out. At this juncture, the defense had done everything we could to request a plea bargain, as the court, as the state's not required to meet with me. And so we'd asked for that, there wasn't one provided. And now, as often the case is, when we get close to this trial setting, new information becomes available. My understanding is that even though after yesterday, a new report was added to the discovery portal, that I have not had the opportunity to review. And so, Judge, I think, I guess I'm seeking clarification. It seems the court says no plea bargain will be permitted.
That's not what I said. The court says it rejects this plea agreement on possession of child pornography.
Okay. Then, I will speak to the state, see, if there is any other resolution. I would ask.
Do y'all want to do that today and
Well,
have Mr. Davis come back at 1:30?
I would ask that he come back. We approach it. If there's some.
All right, Mr. Davis, we'll order you to come back at 1:30 and we'll allow the attorneys to talk further about your case and we'll call you at that time. Okay? Mr. Turnage, come on up. All right, this is cause number CR 26-00081, State of Texas versus Wayne McKinley Turnage. So, Mr. Turnage, I called your name at 9 a.m. Were you present? You weren't in the courtroom. Were you present outside? Okay. So, Mr. Turnage, you're set for arraignment today on a third-degree felony offense for which you've been indicted. That is assault of a family or household member with previous conviction. That carries a range of punishment if you are to be convicted and sentenced to not less than 2 years or more than 10 years confinement. in the Texas Department of Criminal Justice. And you could also receive up to a $10,000 fine. Do you intend to hire an attorney to represent you on this matter? All right, so I'm going to reset you to September 17th for arraignment. And I'm also going to set you on that date for status of your hiring an attorney. When you speak with an attorney, make sure you're speaking with a criminal defense attorney and one that's willing to practice here in Van Zandt County. We're going to give you a notice of appearance for you to sign. If you'll write that charge on there, Mr. Abraham. And the other issue is, and I disclosed this to you, I believe, before we were on the record, that your bondsman, Easy Pickens Bail Bonds, had filed a request to the court for them to go off of your bail. And they indicated in that filing that the reason they wanted to go off your bail was because they could not assure your attendance in court, because their allegation is that you've not been keeping up with your contractual requirements by checking in with them. The court took that under advisement. I didn't sign it whenever they filed it. However, when I called your name at 9 a.m. And you weren't here, then the court announced on the record that it would be granting their request for them to go off of your bond and for a new warrant to be, or for a warrant to be issued for your arrest. It's my understanding through my staff that your bondsman has contacted the court and indicated that they would be willing to withdraw that filing and that request if you are to check in with them today at the completion of this court hearing. So what I'm going to do, Mr. Turnage, is I'm going to take that request from your bondsman to go off your warrant. I'm going to take that under advisement. I'm not going to do anything with it until I hear from your bondsman. If you go over there and satisfy whatever agreement you have with them and you make them happy, and they call over here to my staff and say, we don't want to go off his bond anymore, then I'll just reject it and you'll come back on the 17th with an attorney. If they don't call over here and say that they're willing to stay on your bond, then the court would likely grant that and you would have a warrant for your arrest. Do you understand all of that? Okay, good. All right, so I'm gonna have you sign this notice of appearance. It's got your reset date on it. You're free to go. You've already told me. All right, you said that Mr. Rosser is, you said Mr. Rosser's planning on being here at 1:30, that he was in jail at our last court setting and he's made bond.
Yes. And Nicholas talked to me and he will appear at 1:30.
All right, court will recall cause number CR 21239, State versus Isaiah Rosser at 1:30. Court will recall Mr. Davis on his cases at 1:30 as well. All right, then that resolves this morning's criminal docket. Court will stand in recess until 1:30. We'll resume with the jail docket. On Pinkerton.
Yeah.